Hey, we're live. I'm Greg Siskin. I'm joined by Aaron Hall and Jesse Bless. We're going to talk about impact litigation matters, update a little bit about what's going on in immigration law in the last week, and we still don't have Chuck Cook back. Hoping he's back soon. But we everything we hear is positive as far as his recovery, and good luck, Chuck, if you're watching. As far as getting back on time. Um, Anything you guys want to? Which case you guys want to start with?
Let's start with diversity visas. Just to acknowledge that we're now over 1 year since oral argument. Since a year ago, Jesse and Chuck were
Yeah.
making their arguments, getting their feedback from the judge, from the panel, and we've gone more than a year. I think none of us predicted that. And to the questions, we don't know. We don't know what that means. We don't know when we'll get a decision. We assume soon, but I've assumed soon.
Let me ask you a question. I actually did hear from somebody this week that was a DV 2021 winner, and obviously they have been moving on with their lives. But they had asked the question about it, like if we're successful in this case, and they were not part of any of the prior litigation. Hopefully, Jesse will be back. What are and we get a successful outcome on the case. Presumably it might be possible for people that were not part of the original litigation or not. In different scenarios for how it might work out.
Yeah, I mean anything's possible, I suppose. The way that the underlying district court judge's orders on actually read were different. So some were limited to plaintiffs. Gomez, the one Jesse argued, was a class. There was one from, I think it was Judge Chepkin, that did not limit to plaintiffs but limited to residents of certain countries.
Right.
And so the way, if the orders were just affirmed, then most of the reserved visas for 2021, for example, would be for plaintiffs. But it could be remanded. It could be the scope of the orders could change. And, I think it's just a fool's errand to predict exactly how it'll play out until we see the decision. I don't know if you have other thoughts on that, Jesse.
Just how the relief would go. For the class, it's going to be difficult. How big is the pool right now? Because I think you're going to have to, the difficulty, which nobody really could have anticipated, people are going to have to show up and demonstrate eligibility, right? Not maybe, what has changed in the last 2 years in your life? Maybe people have extra derivatives. How do we count them? How they're going to put together the mousetrap again is going to be really hard and then there's 9,000 supposedly available. I know we've asked for more. Some people have probably found alternative ways. Some people don't want to come anymore.
Right.
It's just going to be a huge, assuming we win, it's going to be a huge kind of shakeout period. Hopefully the government will kind of lay down their guns and start working with us and not against us, because they actually have the information. That's hopefully that's a good problem to have. I hope to have that problem.
Yeah. Okay. Aaron, let's talk about the 601, 601 and 601A cases. So any news on the Boulay, the 601 case?
Not any legal news as far as filings or decisions or anything like that. So the 601A case up in Seattle, that is stayed while we're waiting for a decision from the Ninth Circuit Court of Appeals on another similar case. Right. The 601 case is in Nebraska. That is not stayed. We could get a decision on the motion to dismiss at any time, and we're just waiting on that. So no developments there legally. I would note that we have some very happy news from a number of plaintiffs in the 601 case who've reached out saying that their applications have been approved in the last few weeks. So that's
do we know as far as their dates of filing, if it's consistent with sort of the published processing time dates, or were they faster or slower?
I don't have them in front of me. When I looked, I thought that they were consistent. But not in order. So we have plaintiffs with older cases who have not been approved yet, who have not received an RFE or anything like that. So it's not that that it would give any support for a government argument that there's an orderly line here or anything like that. But I didn't see anything out of the ordinary when I did a quick review. And then, Greg, I think you were saying that you saw some movement on 601A plaintiffs as well.
Yeah, we had 3 more approved over the last week. And so we're at 33 have been approved now. The main thing that I can see here was that looking at these cases is these were people who, all 3 of them, 2 of them look like they had, well, I'm not sure, their case numbers are not that close in terms of making me think they were derivatives, but all were filed in February 2020. So in terms of the published processing times right now are at 44.5 months in Nebraska, 44 months. So essentially the same in Potomac, which is 3 years and 8 months. So these cases are kind of in line with what the published processing time is. So there's nothing really that that meaningful, I think, and these have been approved. My guess is that the litigation probably doesn't have much of an impact on these that we can look at. So but that's what I can tell you right now on it. And I think the government is not under a lot of pressure right now to do anything on those cases other than process them in the same extremely slow way that they've been doing everybody until we get the judges to actually intervene and make some decisions. So I'm not expecting the government to do a lot on these cases until we actually have our judge weigh in. I don't know if you feel differently, or Jesse.
I think USCIS has kind of gone on record now with, people at, whether it's at AILA or, FBA or some other organizations, about how essentially, we've made decisions to decrease processing times for certain categories. And for us to do that, we had to increase them in other categories, and so leave us alone. And that's really their policy. And they feel like they're doing a great job with things. Not so sure that's the way an agency should be run, where you kind of ignore certain customers to help out those that you should have helped to begin with. Everybody's paying, and everybody has kind of a right to a decision in an orderly time. So, I think it's the same thing where, you have a government that's not really doing a good job of managing its resources and time. And it's just that, we could have said that 30 years ago. I think, could have had, my grandfather probably come here and say that to you. I think that the problem is, they are also incentivized, in my view, it's totally my opinion. They're incentivized not to do work because they want more money, and they're probably, they want processing fees to increase, and they want, to do some other things. And, and again, they've had success. They're up 21-7 right now in halftime. So they're in there drinking champagne and, kicking back with a 6-pack like Chris Mullen at halftime. And they think they're going to win. And, we have another half to play. So let's go do it.
We did have a couple of questions relating to 601s and 601As. So I figured we can probably address those right now. Aaron Gustavo had a question. Is there any way to know how many applications? So they do publish some data on the number of applications received and pending. Have you seen anything lately that you can report in that regard? Chuck's usually the master of numbers. So
yeah, nothing that I can get to my fingertips within the next minute or two. But you're right. They do publish statistics.
Yeah. The number I had was 40,000. That was in Q, something like that. I believe that. I'm going to trust my gut on that number is not made up. It was around 40,000 they had in the backlog.
Okay. And we had a question as well on 601As from hold on a second. That was on 601As, sorry. And then we had a question from T Lyons. Do we have an estimate on the on processing times. I was just trying to look that up, and weirdly, the site was giving me an error message saying that. And now it's showing. Now they're saying 21 months on I-601s at Nebraska. That seems significantly faster as far as what they're reporting. Is that a change, or is that a number you've seen for a while?
I would have to look at the most recent filings. I can tell you. So there's a. I'm just opening this up and I'm going to tell you a couple of dates that for cases that have recently been approved. So again, these are I-601 cases. So one that I see was receipted in February of 2022. That was just approved. So that is, what is that? 19 months.
Right. So that's interesting. All right. So that's 90 days faster than the reported time.
We have, I'll just find one other one here.
But overall, that's a significant improvement at the agency over what it was several months ago, which I think they were close. 601s and 601As were fairly close as far as the overall time. Am I wrong about that, or am I remembering incorrectly?
Well, these weren't as at least the posted processing times weren't quite as bad as the 601As. I just see another one that says this one was just approved and it was filed in June of 2020. So that was an older one.
Okay.
Then we had another approved that was filed January 2022. That was just recently approved.
All right. So that's about 60 days faster than the published time.
Yeah.
Okay. All right. Interesting. Okay. And the another case that is our Astakov Ukrainian case, Jesse. So we're in a. Can you explain the procedural, the stage of the process that we're in right now? Because we're still not at a point where we're actually able to make. The judge is not making any decisions on actual substantive arguments about whether the government owes the money or not. But we're in this dance right now over venue and over class certification. So can you just tell folks a little bit about what's happening?
Yeah, I mean, essentially right now the judge has kind of paused everything except for the government's motion to dismiss or change venue. And I think everything else in the case has stayed, production of a record, motions for class certification. I think everything else is, kind of off, paused, because I think the Judge Boasberg, who's the chief judge in DC, and who actually, he rules fairly quickly compared to his peers in the court. He sets the table as the chief judge too. So, I think he needs to decide whether he gets to, keep the case, or he's going to, kick it to the federal court of claims or perhaps another district court. It makes sense.
He was our judge in the Milligan case, right, Aaron?
He was, yeah.
He
former Yale basketball player.
Oh, really?
Yeah.
But it is one of my favorite decisions because he was referencing Shakespeare in his decision, which I remember.
He kicked my ass in the DaCosta case and quoted Field of Dreams to make the analogy to an immigrant investor on an EB-5. And actually, 2 days ago, he issued an interesting case, and it's actually relevant to maybe not to the Ukrainian case, but to a lot of delay cases in DC where I represented I do represent a group of Iranian students, and the government came in and said, listed like seriously 47 arguments that they stole from each other to say that you could never, how dare you even think that you could get a decision on an F visa? Like, this is insane. Like, get away. We can do whatever we want forever. Go away. Oh, and by the way, you're Iranian, so you're presumptively ineligible for any non-immigrant visa. So get the hell out of here. And he did a nice job of one of his comments where you cannot unsubscribe from making a decision. That's not allowed. It's just that in our case, unfortunately, what judges don't understand is the time sensitivity to an F or a J visa, and felt like a year was not long enough to wait, even though a year in school terms is, like, it's over. You don't get your program. But so I guess all to say, for the turning back to the Ukrainian case, it's really, there's arguments to be made on both sides. And we just need to know where we need to make the arguments that we have on the merits, and to get these refugees their money back. And I use this case. I think we talked about this last week. I mean, for people who think that you throw out litigation and you just win, this case is like example A for why that's never true. Because the government sometimes fights on principle and doesn't really look at the human aspect or the arguments. I just don't understand why we're fighting this case. Still,
well, I understand why we're fighting this case, because the government doesn't want to pay. The USCIS doesn't want to find the money.
It's a treasury. I mean, Jesus, we're printing it. I mean, just
Yeah, but I mean, it's like they still have to ask Congress for it. They can't just sort of like say we were held liable in the suit.
Well,
under the mandate that you gave us, and so therefore you have to give us the extra money. I mean, it'd be nice for us if the government had sort of an automatic funding for unfunded mandates that the Congress imposes. I mean, I get USCIS why they would be frustrated by that they had to, in theory, do this work. Although they didn't have to do the work on there, but in theory they had to do this work, not charge a fee, and come up with other places in their budget for it. But that's how it works. So it's not a question of like, that's too bad.
If I was 104 years old and ran for the Senate, this is what I would say. Your legal bill is going to be higher than what you probably pay out to these refugees. So what the hell are you doing? We're going to pay you anyway. Why don't we pay you not to do this stupid litigation? And why don't you do the right thing? Because we're giving money to Ukraine. So we're buying bombs, we're shipping them over there. Why don't we just help the people we've let in here so that they can provide for their families? I mean, it just doesn't, it makes too much sense. So that's why it won't work. Yeah. But I mean, again, I think, I really do believe that this has been their position in this entire case. If we just stall and we just do it the minimum, it'll go away. And maybe we can win on a technicality. That's how I felt like this whole case has been. And honestly, I've lost my innocence in this case. Like, I was defending them.
Yeah, I mean, they would like if a technicality happens in this case. But I mean, the technicality is going to mean ultimately that somebody. Well, they're going to lose. I think and I think they realize they're going to lose. The only question is going to be whether the loss itself is super expensive or a lot less expensive for them, depending on whether they're successful in these initial procedural fights. If they can, that I think is the calculations that they're going through. That I don't think there's probably a lot of people saying, "Hey, let's fight hard because we could win on this." I just don't see them winning on the substance of it when it gets to that. The only question is going to be, I think, on procedurally, whether it's harder for the plaintiffs to be able to be fully compensated.
In other words, how much of this money that we were never entitled to keep?
Exactly.
Yeah.
Yeah.
So I wanted to go back to Gustavo's question about 601As for a second. He asked for some data, and I looked it up. And for I-601As, the second quarter, they received 9,000 new applications. During the second quarter of this fiscal year, they adjudicated 2,000. So we're adding to that backlog. For those ones that were decided during the second quarter, the median processing time was 42 months. And as of now, they have 134,878 I-601As pending. Again, that's as of the end of the second quarter of the fiscal year. So It's not too rosy.
No, but unlike other categories, there's no limit on how many that they can adjudicate. So these aren't like backlogs that are structurally in place because Congress has done it that way. So, ideally, it is at least it's solvable from the agency's perspective, and it's not dependent on Congress stepping in.
It is, but let me repeat something because I didn't say it very clearly. The fiscal year to date, so for 2023 through half of the year, through the second quarter, they had 134,878 applications pending. During that time, they adjudicated 3,590.
Yeah. So that pace is going to be a long time.
I mean, we're talking big commitments and reforms or something that they need to do to make this happen, because this pace, and again, this is after their big announcements about Heart Service Center, about everything they're doing to bring down processing times, since the director has said these times are unacceptable. This is after all of this. We're midway through the year.
I'll tell you what you do is you
done.
You say, listen, you're gonna pay me $410. I'm gonna let you work. I'm gonna get you deferred action. Agency gets their money for 8 minutes of work, right? You pay $410, times that by 100,000. Here we go. Then you can hire the officers to get this back to I mean,
there are solutions that they're willing to be a little bit bold on there.
That's not even bold. That's like, dude, like, let's let them, like, that's normal. You're not removing them.
No.
So let them.
But it does requires them to be a little out of the box in terms of what they can do, and it seems like they're not willing to do that unless they are pushed to do things.
I'm just saying, if
litigation is designed to be the push.
Totally.
So
they could, yeah. I mean, I look at it this way: your house is burning down. You've been using your hose in your backyard to put this fire out. It's not working. Like, you got to do something else. Like, seriously, you got a problem on your hands.
So in this discussion, Daniel is asking a question about 601 waiver legislation for cases still pending. I would not expect any help from Congress on any immigration matter at this point. They've yet to do anything of significance. The only thing that was immigration related was on the Ukrainians, which is what we're litigating over. The one time Congress actually did something good for immigrants, the agency hasn't had to be sued in order to actually implement. But Congress, in terms of solving this, we just have the House is not going to vote on anything that is remotely helpful for immigrants. Unless it's part of a bigger package with must-pass stuff in it, but I would not count on this being solved.
Yeah, I mean, if they're not going to do DACA, in the next election year, if they can't push that, I mean, which they.
Right, we'll get to DACA in a second because there was some news. But let's go to some of the questions, unless there's any other cases we want to talk about.
No.
Okay. So Nagesh had a question regarding incorporating a business while you're on F1 STEM OPT. So there is an FAQ somewhere on STEM OPT, and it is possible to be self-employed with your own company on STEM OPT, I believe. But STEM OPTs does have a lot of, there are requirements for E-Verify and all this other stuff. But I'm not sure if you're talking about, like, if you're working for another company and then you're like looking to start up a second company while the first one is happening. So this is when I want to get Adam Cohen, my law partner, on, who writes a book on all things student immigration. But it is I believe, first of all, you can always incorporate. You can always incorporate a business, even on a tourist visa. You can incorporate a business. That's not what's prohibited. What's prohibited is unauthorized work for that company. So if you're going through all the preliminaries of setting up a company, that itself is not going to violate your F1 status if you're opening up bank accounts and going through incorporations and doing all this stuff, but it's not actually making any money and you're not actually delivering any services or building any products. So that the literal question of whether you can incorporate a business is fine. Whether you can start doing business while you're on F1 STEM OPT, I think the answer is yes. but don't rely on my answering this right now. There is a somewhere in the STEM OPT FAQs. This is specifically addressed. But Nagesh, if you want to shoot me a message, I'll see if I can track that down for you, the specific citation on that. And if I'm wrong, that's why I'm telling people, I'm giving that disclaimer right now. Don't rely on this. Check with your lawyer, but I'll check for you myself if you want to send me a note. Let's keep going. Deepak, if you listen to the recording on this, we gave the quick update. We really don't have any updates right now on when the decision is going to come in on it. And we are marking the 1 year anniversary. What was it, September 22nd last year that we had our arguments? But it's we're anxious, just like all of you, as far as when this decision is going to come. Granado's case. Do you guys know which one Brittany's talking about?
That one is the Colorado case.
Where right.
The judge set a conference to talk through possibility for discovery.
Okay.
And I haven't heard from counsel for Granados in a couple of weeks, and so I don't believe that there's been any decisions made on discovery yet.
Okay. I'm looking for new questions here. There's some discussion going on the chat with each other that don't need to be brought up here. Let's see. Oh, so Emily's asking a question since we've talked about DACA before. So that's one of the areas where there was some recent news. It was actually last Wednesday that we had the news that is it Judge Hannon down in Texas, who's handling that litigation over DACA. He gave another decision in favor of the plaintiffs, which is the Republican governors. But basically, it's the status quo continuing. This case is eventually going to make it to the Supreme Court. I guess the question is whether it's going to be this year or next year. I'm guessing that's probably going to be this. If the Fifth Circuit does something where they shut the program down, order the program shut down, it will go very quickly to the Supreme Court, at least initially, for them to make a determination on making any change like that. But I'm assuming that it's going to probably be next year in the Supreme Court, not this year, that they're going to hear like the full substance of the case. But the court basically, so there's not much of a change in the, we're basically where we've been, which is that the same people are eligible that are in the DACA program are eligible for extensions. People that are not. I mean, if you're not in the DACA program at this point, you can't get an initial application approved. I don't know if you guys have any other takes or.
I mean, I would say, I mean, there's obviously an argument to appeal on standing and I guess some of the substantive arguments, but if you're going to go through the Fifth and then think about going to the Supremes, maybe when they're on standing, but maybe you just wrap it up and say this is small. I mean, I don't know. Like, can it be worse? I mean, could they take it away for those that already have it? That would be my primary concern because.
Yeah, I mean, it was interesting, that decision. The last decision this judge issued, he was complaining that the administration didn't follow the APA and go through rulemaking and all of this. Then they do go through rulemaking and they do everything. And then the judge at that point says, oh, it's all a facade, basically, just to ensure that the previous memo gets in. So it's like, you can't win with this guy. It's like he said that this was the problem with it. And then they do everything by the books as far as implementing that regulation. And he says it's still not good enough on there because I know what you were doing. You were, and not. The bottom line is he doesn't like DACA. I think that's the problem. He doesn't like the policy, and so he's going to come up with whatever he needs to justify that. I don't think but that's the good thing about at the Circuit Court of Appeals. They're not going to basically, I think, be as reckless. I think in terms of how a decision gets made, where it's just basically pretty clear that it's the judge's political agenda that's driving the decision. That's not to say we're going to get a decision we like, but I do think that the fifth will, they will give a more thoughtful, hopefully give a more thoughtful decision as far as, and not just completely dismissing the rulemaking that just happened.
Well, I haven't done a deep dive on his order here, and I'm not going to. But I'll tell you that from what I've read from other people who have, he didn't really go back and redo his standing analysis in light of U.S. v. Texas.
Right.
And it's hard for me to understand how the states, who are the plaintiffs in this case, have standing after the Supreme Court's decision this term in U.S. v. Texas, when they said basically, a speculative wave at future financials considerations isn't enough for a state. So
right. So that's a good point as far as sort of like if they, they can just do this procedurally and get rid of this case.
Well, I think the Supreme Court, I think that there are a number of members who enjoy having a way to not address the merits of the claim on DACA, who like the program deep down, or realize that it would cause chaos and a lot of unrest if it were eliminated, who might just say there's no standing after Texas. So like John Roberts, when he wrote the decision blocking the Trump administration's attempts to do away with DACA, he did it on some APA grounds. I could easily see him.
I think you're right on that. In which case, if they did that, then basically, then the rule would actually take. The rule would happen right now.
The regulatory rule.
So it wouldn't expand DACA to people that came after the original dates under the rules. It's still basically that, but it would allow all these people who would have been eligible to file that have been held up. And that's a lot. That might be a bigger population than the DACA population right now, is all those young people that were behind them and the younger ones that were too young to file. That would be able to file now. So,
but it's still all of it still leaves the elephant in the room is, what do we do with people who've been on DACA who are about to be eligible to retire? Like, seriously, like what the fuck, and this goes to show, like, when we talk about all these problems, I mean, if Joe, and I blame Joe, and I do, and I blame the Democrats. If you're not going to do something, if you can't get people invested enough to solve this problem, because the problem's not going away, and ignoring it is ridiculous. And it's going to take legislation, and you got to deal with it because it's not going anywhere. And I think,
although TPS, he could do, they can move a huge chunk of this population into the TPS program, which is a lot harder to attack in litigation.
Although you're right, but now TPS, and again, I'm not as steeped into it, but the agency doesn't really like to adjust people on TPS who get parole.
So, if you're just talking about right now protecting these people.
Oh, totally. But here's the thing. I don't, for a million years, these people aren't going anywhere, right? Yeah. That's not happening. I think what we need to do is make them, we owe it. I think our citizenry owes it to make these people permanent residents. that's just our obligation.
Oh, I agree with that 100%. But I'm saying, when you're talking about what the administration will be doing, the administration can't make Congress do something, but they have.
Oh, totally not. But we got to push here. We got to, and I tell you, it's an election year coming up, right? I'm just looking at it like he really has not energized that part of the base, which is a huge base. And there's a lot of local elections where this would be a giant win.
Yeah.
And I'm not saying it's going to get through. Republican
Obama figured that out in June 2012 when he came up with DACA on there, and it was a few months before the election. We're in this period right now where a few months, it's not quite as close, but it was a winner for him. And it might have made the difference in a few states that, you may recall in the spring and summer of 2012, that Mitt Romney was not we think of it now as like, of course, Obama was going to win. That's not true. Obama's reelection was far from assured. I remember the thinking feeling after the first debate with Obama, he did really pretty poorly there. and the poll numbers were not great, that this is not going to go well for him. DACA, I think, was sort of one of these sleeper issues that really politically delivered for him. And I think that, Biden needs to sort of lean in. I agree. There was another issue this week, which you probably heard from your clients and heard on social media. And it's really puzzling, I think, in a lot of respects, what there's such a lack of transparency at the State Department on how they are drafting this bulletin, where they're coming up with their numbers on there. But that is the visa bulletin coming out this week, I think, was just sort of it was a gut punch for a lot of people who are we only really get big advancements typically on that October visa bulletin. So, what the State Department was telling us is that don't count on any really good news for a while. The one thing I do think that this is another example, though, the Biden administration really having a lot more. There's a lot of shrugged shoulders in this administration saying, we have no choice. We're sorry. Congress needs to act. I'm sick of them saying Congress needs to. This is Congress's problem to fix. It is true on broad immigration reform, but this is the perfect example, Jesse, of something where there are policy options at their disposal that could dramatically improve the lives of all these people that are in the backlog. Our friend Cyrus Mehta has given he's talked about this over and over again. The actual language of the statute allows for them to allow anybody who has to file to adjust status, and not just based on the visa bulletin. And that's based on the plain language of the statute, which says a visa needs to be available in that category. And as long as visas haven't been, as long as one number has been left, then that gives them complete authority to be able to adjust everybody that applications. And that would probably raise the GDP by a full percent.
Yeah.
If they had that would be like rocket fuel for the economy, as far as letting all these people change employers, start companies up, ask for raises because they, and do a lot of things. I think that would.
But this is a political statement. I mean, the visa bulletin now are political statement.
Yeah.
Did I lose everybody? No. So see that deep state right there come at me. So it's a political statement now, because it's not that they didn't hear the message.
Yeah.
It's not that they don't know, but they're making choices, whether it's to, I don't know who in labor thinks this is a good idea, or they want to suppress certain categories like Indian EB1As, and then they want to accelerate, they're it does show you that there is that advocacy in some ways can help, maybe some big bucks, because they did accelerate like certain categories of EB5, and that's great, and do it, and that's fine. But
well, they also and they have a second option aside from that, the Cyrus theory, which and that's not counting derivatives. The language is precisely the same for H4s as it is for derivatives in EB1. H4s, for some reason, they look at that same language and say, that they don't have any impact on the number of H1Bs we give out. Derivatives don't count. And then on employment base, with the exact same language, they say, for this purpose, it does. And the reason, look, I mean, they had this all stems back from we didn't get quotas in H1Bs until 1990. And that's when they came up. So they had the opportunity to look at that language in 1990 when that bill was coming out. And that's the way they interpreted that same language then. Now they act like it's basically like, written in the tablets that came down from Mount Sinai, that they have to interpret the language the way the State Department looked at it 50 or 60 years ago, when they were saying that we're not going to count derivatives. But that is not in the statute. That is strictly an agency interpretation. And just because you've interpreted it that way for a long time doesn't mean that you need to keep that way, particularly when you have that exact same language and you're interpreting it in a different way for purposes of another program. So I think they have a lot of latitude on that one, and that would triple the number of green cards that they could issue each year.
it's really, the visa bulletin is a great example of, you know, like a government failure. Like, you cannot trust, you know, there's no transparency. Why don't you just show us your numbers? Show us your math, right? My kid gets a 75 if he doesn't show us the work, right? Show me your work. You can't, they can't explain it. They can't explain it. I mean, again, you know, these people, they put in numbers, and if the wrong numbers go in, the wrong numbers come out.
Yeah.
And so they really don't know. And so it's an exercise in guesswork. And again, it goes to the failure of, why not make it easier on yourselves and do some of the things that we're saying, so you don't have so many people who are in such a state of chaos? Like, yeah, like, I think Congress is, you know, that's so funny though, that they want Congress to act, right? And they blame, you know, it's just, it's unfortunate, but I'll tell you, a lot of people were hurt. And I go back to the, you know, the courage that you guys had. I wasn't a part of that lawsuit when you knew that wasting visas were going to have an incredible impact on the lives of people and companies. And, you know, unfortunately, you deserve better from that asshat in Maryland who put it to you, you know,
well, and we also deserve better from USCIS, which ultimately wasted 60,000 green cards.
Totally. Yeah. I mean, that's the thing. Like, it's so crazy, right? Like, they were, oh, poor me, we don't have the visas this year, right? So the narrative changes, and it's like, wait a minute, you know, let's not forget. And, you know, so it's just too bad. It really is. It's so many people get hurt by avoidable issues.
But I will say, like, to put a little bit of a positive spin on that, the advocacy of the community affected by that, in combination with litigation, I think is what made USCIS commit to using all employment-based visas, or trying to on an annual basis.
Right. Which can be said as well for the green card lottery, which is
exactly
that, you know, that they in subsequent years they did better, but, you know,
I still think the best argument that was never, I guess, resolved on the merits was that, you know, the visas should not just go and extinguish and disappear, that you could have carried them over and maybe kept them alive. I don't know. I think that was another argument that could have been made, that you don't have to just make them disappear, that they can.
Yeah. All right, we're going to we three of us actually unfortunately have other obligations, so we're going to have to wrap it up. But and hopefully Chuck will be back next week, maybe not, but we look forward to his return. And we will obviously update our plaintiffs and any breaking news on these cases that are of significance in between now and next week. Otherwise, I will see you guys next Wednesday. And thank you, everybody.
Yeah, be good.